Case 1, Simpkins and Wright versus Wright, the car repair dispute. Background. Parties. Plaintiff, Ms. Wright, ex-girlfriend, and her father, Mr. Simpkins defendant, Mr. Wright, ex-boyfriend. Relationship. The couple dated for 2.5 years, lived together, and even shared a joint bank account. The car. They purchased a car together in 2013 with a $1,000 down payment, paid by the defendant. Title was in both names. Repairs. The car broke down twice. Repairs totaled $5,041, all paid by Mr. Simpkins, the plaintiff's father. The expectation was that the couple would reimburse him. The dispute. After repairs, the relationship ended. The defendant took the car when they broke up, leaving the plaintiff's family with the debt. Later, the plaintiff repossessed the car, which eventually stopped running and sat unused. The central fight. Who owed repayment for the father's $5,741? Plaintiff's side, Ms. Wright and her father. The father paid up front with the understanding the couple would reimburse him. Both partners benefited from the repaired car. Defendant only paid a small portion, $400 in reality, not $1,600 as he claimed. It was unfair for him to walk away with the car while her father carried the debt. Defendant's side, Mr. Wright, admitted the father paid but argued. He never directly agreed to repay Mr. Simpkins, said the agreement was only between the father and Ms. Wright, claimed he had already repaid $2,600 in installments, stopped paying when he realized Ms. Wright wasn't contributing, agreed to sign off his name on the car title, to wash his hands of the mess. Judge Judy's role, sorting the agreements, pointed out there was no written contract between the father and the defendant, highlighted that vague promises like "I'll pay what I can" are not binding. However, she emphasized that both partners benefited from the father's payment while they were a couple. Breaking down. Responsibility. Total repairs. $5,741 divided equally, $2,870 each. Defendant claimed he paid $1,600 already, but even giving him credit for that, he still owed $1,270 on young couples sharing assets. Judy scolded both sides. Couples who aren't married should not buy cars, houses, pets, or timeshares together, called it messy, and reminded them courts don't exist to divide property between almost marrieds. Final orders. Defendant must pay $1,270 to the father. Defendant must sign off the car title within 5 days so the plaintiff's side can sell or dispose of it. Defendant's counterclaim for repayment was dismissed. Ruling. Judgment for the plaintiff, Mr. Wright owes $1,270 to Mr. Simpkins. Mr. Wright must remove his name from the car title within 5 days. Lesson: if a parent covers expenses for a couple, both partners are responsible, at least while they're together. No contract, Yerka's limited legal power, but fairness still counts. Judge Judy's core message: don't tie finances to a romantic partner unless you're legally married. It only leads to messy disputes when the relationship ends. Case 2. Pesterfield versus landlord, the no plumbing apartment. Background: plaintiff, Mr. Pesterfield and his fiancée. Defendant, their landlord, a woman who rented out a small apartment space on her property. The rental. In October, plaintiffs answered an ad for what was advertised as a 1-bedroom apartment at $700 rent. Reality: the space had no plumbing, no running water, and no kitchen. The landlord initially told them they could use the main house kitchen and bathroom until plumbing was installed. She also sent a Facebook message offering that they could stay rent-free until plumbing was fixed. Plaintiff's side, tenants, claimed they were misled into believing plumbing would be installed within a week, paid a $500 security deposit plus some rent, $400 in October, then regular rent after. Said they often felt unwelcome using the main house, claimed the landlord harassed them, turning water on when they showered, complaining about noise. By January, they stopped paying rent since the plumbing still wasn't fixed. Finally moved out in February, breaking the lease, and sued for return of the $500 security deposit. Refund of all rent paid, arguing they never got a habitable apartment. Defendant's side, landlord, insisted plaintiffs were tenants, not guests, once they started paying rent. Claimed they caused property damage, holes in walls, carpet ruined, left a Christmas tree in the yard. Filed a $5,000 counterclaim for unpaid rent and damages. Argued that she tried to have plumbers come, but plaintiffs wouldn't let them in due to their sleeping schedule. Judge Judy's role, establishing tenancy. Once plaintiffs paid rent in October, they became tenants regardless of the plumbing situation. Judy acknowledged that while the unit was substandard, the plaintiffs chose to keep living there month after month. On rent refunds, Judy compared it to eating a steak at a restaurant. You can't eat it and then say you won't pay just because it wasn't good. Since plaintiffs lived there, used the facilities even if inconveniently, they could not get all their rent back. On security deposit, the only valid claim was for the $500 security deposit. Landlord showed photos of damage, but Judy dismissed them as mess, not damage. No receipts or bills were produced for repairs or trash removal. On counterclaim, Judy was clear. You can't rent a place without a bathroom or plumbing and then expect full protection from the court. Dismissed the landlord's $5,000 counterclaim as unsupported. Ruling. Plaintiffs win $500, return of security deposit. No rent refunded. Landlord's counterclaim dismissed. Lesson. Tenants. If a rental is unlivable, move out immediately instead of staying and then demanding a refund. Courts won't erase rent if you chose to stay. Landlords. Don't rent out units that lack basic necessities like plumbing. Courts expect written evidence, bills, receipts to prove damages. Judge Judy's blunt reminder. If you're unhappy, move out. You don't get to live somewhere, use it, then refuse to pay.